Hello, my name is Vasily Tarsenko, I'm a Russian attorney. One of relevant but at the same time complex issues in the property relations is the division of business assets of spouses of their marriage ends. Difficulties in dividing a business between former spouses are due to the fact that relations associated with family business are regulated not only by family law but also by corporate law, because in this case we're talking not just about protecting the rights of each spouse, but also the rights of third parties, such as other business participants and counterparties. What are the legal norms? The Russian Family Code states that all property acquired by spouses during marriage is their marital, that is, common property. In addition, the marital property includes the income of each spouse from labor and entrepreneurial activity and the results of intellectual activity. It also includes securities acquired at the expense of the spouse's common income and shares in capital contributed to commercial organizations, regardless of which spouse's name the shares are registered in or which spouse contributed the money. But what is meant by the word business is not an independent object of rights, that is, it cannot be divided in the same way as a car, apartment or money. Business is an activity done either in a commercial organizations or in the form of individual entrepreneur. And their division is carried out differently. The first is individual entrepreneur business division. First, a simpler case, when the business was carried on the form of an individual entrepreneur. It's simple here. Everything that the individual entrepreneur has is divided equally. The matter is a feature of individual entrepreneur business is that the entrepreneur's property is inseparable from the same individual's property, since an individual entrepreneur is first of all an individual who is engaged in entrepreneurial activities. That is, an individual entrepreneurial business is not an independent object of civil rights and thus is not subject to assessment and division. However, property acquired by an individual entrepreneur during marriage, during their entrepreneurial activity, as well as income from this activity are community property. In other words, if a divorce involves this type of business, then trade, equipment, inventory, transport, revenue and funds in accounts will be divided. In general, everything that an entrepreneur owes is exactly the same as if he didn't have the status. On the other hand, this position seems justified. But on the other hand, a spouse who doesn't have individual entrepreneur status may find themselves in a losing position, since if the spouse who is individual entrepreneur has a license, some property rights, for example, a lease right or established reputation, then they will not be taken into account. That is, if the same business were operated as an LLC, then a spouse who doesn't have individual entrepreneur status could claim half the share or compensation in the amount of its actual value. In the case of an individual entrepreneur, he or she will not receive, let's say, compensation for such non-property rights, and even after the division of property, the individual entrepreneur will continue to make a profit, while the second spouse will receive only 50% of the value of the property after its division. Second type of business is limited liability company division. The second, much more complex case is the division of shares in an LLC, known as OOO in Russia. Shares in the authorized capital of a commercial organization acquired at the expense of the common income of the spouses are also marital property. Note that the right to a share in a company is a combination of property rights, receiving dividends, distributing profits, etc. Liability, corporate rights, participating in managing the affairs of the company, getting acquainted with its documentation, etc. These rights can not only be exercised by the participant in the company. In other words, if a married person buys a share of the company, this share is a marital property, but in the company share is only one spouse, the one in whose name this share is registered. And the spouse of a company participant who is a co-owner should be considered as a third party, not as a participant of the company. The legal status of a LLC and the legal status of the participant are regulated by the Special Regulatory Act Federal Law number 14 or about the limited liability companies. The mere transfer of a share in the authorized capital of an LLC to one of the spouses resulted from the marital property division doesn't automatically entail the acquisition of the status of the participant in the company. The law distinguishes between the rights of the co-owner, who is a member of the company, and rights of co-owner, who is not a member. The difference is expressed in the scope of their rights. For example, the first, unlike the second, has not only the right of ownership of the share, but also rights of obligation is in relation to the company. But the spouse of an LLC participant having received a share of a company as a joint marital property acquires property rights and not the right of a company participant. So we can conclude that a spouse claiming to receive part of the share in the authorized capital of LLC in any case has the right to lay claim to half of actual share in the form of monetary compensation. Moreover, these compensations shall be paid by the other spouse, the owner of the share in the company, and not by the LLC itself. The rules of leaving an LLC are not applicable in this case, since the person doesn't have the status of a member of the company. Second is a spouse claiming to receive a part of the share in the authorized capital of the LLC also has the right to offer themselves as a participant in the company, but only if certain conditions are met. In particular, one should analyze the articles of association wherever it is possible to alienate the share to third party, that is the spouse. What the conditions of its alienation are, for example, the requirements to obtain the consent of the company's participants to transfer the shares to a third party, etc. The next logical question that may arise is how to determine the amount of monetary compensation to be paid to the spouse of a company participant. The spouse must be paid compensation based on the actual value of the share in the authorized capital of the company, determined in the basis of the company's financial statements of the last reporting period preceding the spouse's request for division of the property. This actual value corresponds to a part of the value of the company's net assets proportional to the size of its share. The net assets value is the difference between the value of the organization's assets accepted for calculation and the value of organizations' liabilities accepted for calculation. Companies prepare annual accounting financial statements for a calendar year, and if an actual share value payment demand is made, for example on June 15, 2023, then its value must be determined on the basis of financial statements as December 31st, 2022. If the law, bylaws, or articles of association of the LLC requires the company to submit interim financial statements, then the actual value of the share is calculated based on the interim balance sheet. That is all. Hope you found this video useful. My name is Vasily Tarasenko. Bye.